Good morning, everyone. I'm going to start with the new topic appointment and removal of judges. The chapter is Judiciary and the book is NCERT Class 11 Political Science. So, the appointment of judges, it has been politically controversial, and yet it is also a part of political process. So, these are two contradictory statements. First, political process, it means government, it has a role in both the appointment and removal. So जजेस के अपॉइंटमेंट एंड रिमूवल दोनों में इन दोनों में से किसी का हाथ होता है. So the appointment, it is done by the executive, while the removal, it is the power of the legislature. And yet it is politically controversial because judiciary is the only branch with the power to interpret the constitution. और ये इसका मतलब क्या होता है? How is interpretation of constitution that powerful, and what makes this whole process so controversial? It is because, let's take a background look at what constitution is. In that way, you will be able to understand this situation in totality. So constitution is the agreed common rule or rule book. So constitution एक ऐसी rule book है, एक ऐसा law है which has been agreed by all of us. It is not that this constitution, it has been given to us, or we have borrowed it, or it has been shouldered upon us or burdened upon us. It is not the situation. We have adopted it, we have accepted it, and it is us who drafted this constitution. So in short, we let's start with the beginning. First, we agreed with the basic concepts. Then we created the rule book, and then we adopted the rule book. So all in all, from beginning to the end, the core actor, it was us. Us means we, the people of India. So this rule book, it has been agreed upon by us. So why is appointment of judges in one such branch of government is being politically controversial? Judges तो नहीं कहते कि ये प्राइम मिनिस्टर कैसे इलेक्ट हो गया, या UPSC is not selecting good IAS officers. So it isn't the vice versa situation, and that would have make sense if the situation would be like that. All the three branches of government, they are talking about each other, talking about the appointment and removal of the office holders of the members of each branch. And in that situation, this process, this whole conflict, it would have been competitive and reciprocative in sense that each one is pointing fingers at the other. So all in all, this would have created a healthy competition and would also have put checks and balance in the appointment and removal of all members of office holders of all branches. All members of office holders of all branches. It means whether it is executive like ministers or IAS officers, or in legislature such as parliamentarians, member of parliaments, or in judiciary like judges. But the situation is, judges or judiciary, it is not pointing finger at the appointment process or the recruitment or the election process per se. The same way executive and legislature, they are putting fingers or pointing fingers at the appointment process of judiciary. Reasons which are two. First reason is that Judiciary is the only branch which has the power to interpret the constitution. And second, the appointment of judges, it has been a kind of situation which can be called discretion shrouded in independence. And the third reason, it is independence. Independence of judiciary. So the reason is it is that all the branches of government, they are deriving power from constitution, the rule book, the house of law, which gives power to all the institutions that we see today. Prime Minister and Parliament is there because Constitution says so. IAS officers, IPS officers, diplomats, secretaries, they exist because Constitution says so. Judges, chief justices, advocate, lawyers, they exist because the Constitution says so. So the Constitution is the rule book which delineate the political, social, and economic functioning of society. So all such functions would have been there even if Constitution was not there. Like अगर Constitution नहीं होता फिर भी देश तो चलता ही, फिर भी लोग कमाते ही, economic activities would have run on their full course. The social events, social situations, or social settings would have been there, and some different kind of political process would have also been there. But it is the Constitution, and I say it again and highlight this fact again, that it is the rule book that has been agreed upon and accepted by people themselves. So this is why everyone, all such institutions, they are following what Constitution has mentioned, because the power to, or the idea of how a country should run, how all the aspects of a society should run, it rests on people, and people, they have delineated, they have listed all such activities and their procedures in the Constitution itself. So, and the controversy is there because these three powers, the power to interpret the Constitution, the discretion that is associated with the independence of judiciary, and the clauses of independence of judiciary themselves, all three powers, they have been given to the judiciary, and the mechanism by which these three powers manifest in reality, or in short, what these powers are, what these powers are, ये power भी, ये decide करने की power भी, it has been given to the judiciary itself by the power of interpretation. So it's like it may seem like a situation, it may appear like a situation that the judiciary is setting rules for itself. So the real thorny issue is that judiciary is setting the rules for itself. And यहाँ पे, by looking at all the three powers, one can imagine that judiciary has been given too much leeway, too much discretionary powers. They can decide what the rules are, they can decide what the independence means, they can interpret the constitution. So all in all such interpretation, they may be subjective, they may be subjected to individual choices, the choices of that are held by chief justices, the choices that are held by the higher level of the higher elites of both Supreme Courts and High Courts, Supreme Court and High Courts. So, in order to avoid the situation, both legislature and executive they try to rein in on judiciary. They try to uh, put a power on the excuse me, not power, put a check on the power of judiciary. So that this is why this whole situation is so political. And then the other dimension of being political here is that in the appointment, the constitution, even if the interpretation it rests with judiciary, the constitution makers, the members of constituent assembly, वो लोग they had a foresight that this situation might arise, and that's why they try to keep the whole situation balanced by principle of checks and balance, by which we have three organs: executive, legislature, and judiciary. So the judges they are appointed by the executive, whereas they are removed by the legislature. An executive is comprised of three pillars. First, the permanent executive, then the political executive, and the president. And in the legislature, it is the lower house, the upper house, and the president. So this is the gist of the political issue that are associated with the appointment of judges. Then the political philosophy of judges, which their views about active and assertive judiciary or control or committed judiciary, it may have an impact on the fate of the legislations enacted. So let's have a look at the statement in a broader way. So again, the three pillars of government: executive, legislature, and judiciary. Now, the function of legislature, it is to make laws, to legislate. The function of executive, it is to implement those laws and policies. It is the implementing branch of government. And the role of judiciary, function of judiciary, it is to resolve disputes and interpret the constitution. So the situation may take an ugly turn. For example, a majoritarian government has been elected. Majoritarian means that government that has the support of majority, which has one lot of seats, majority seats, one majority seats. Now, this majoritarian government, it may try to make laws which may be beneficial for one section but harmful for another section. All in all, the rules made by such a majoritarian government or majoritarian political party, it has some bearing on both the people and the constitution itself. So legislature जो भी कानून बनाता है, जो भी law बनाता है, judiciary has to look into its constitutionality. So constitutionality means whether the law made by the legislature or the legislative branch of government, it stand stands true to the spirit of constitution in both letter and spirit, which means जो भी कानून बना है, it must be compatible with the basic structure of constitution. Because ऐसा भी हो सकता है sometimes if the same majoritarian government It may try to change the whole constitution itself. And it has happened once and it may happen twice. So in that situation, judiciary it has been given the power to interpret the constitution. And now let's suppose if executive is appointing the judges and judges are interpreting the constitution, and if this process appointment of judges it has been solely given to the executive or the what we call the council of minister or the cabinet in reality. So if the cabinet has all the power to appoint the judges, then the whole situation, whole the talks of constitutionality, the constitution, the rule, the principle of fairness, all stands futile. क्योंकि फिर कैबिनेट उन्हीं जजेस को अपॉइंट करेगा जो उनके बनाए कानून को सही साबित करे. So there won't be any negative interpretations. All such rules, all such laws and policies and amendments that are approved by cabinet or the council of minister, they will be accepted by a judiciary that is solely appointed by the cabinet, which is called a committed judiciary. So judiciary, it will be committed to the whims and fancies of the executive. And in that situation, there won't be any meaning of rule of law and fairness, principle of fairness or checks and balance, and all such liberal principle, all such principle upon which the constitution was made, they will stand demolished. So to avoid any situation, the members of Constituent Assembly, they had this foresight. They were a bunch of really committed and intelligent people. So we will talk about the intelligence later in the whole appointment process. But right now, for you, it is worth knowing that we have been blessed with one of the best constitution of the world. So this active and assertive judiciary is a situation when the principle of checks and balance it runs in full force, and the uh, appointment process it will not be tempered by the executive branch. But the same situation can change if the appointment it become fraught with the political process, the political controversy, or judges cabinet के इशारे पे काम करते हैं, then they will be called control and committed judiciary. And this difference it has an impact on the fate of legislation enacted. Then, as far as the appointment of Chief Justice of India is concerned, over the year a convention had developed whereby the senior most judge of Supreme Court it was appointed as the Chief Justice of India. So this appointment of Chief Justice of India, Chief Justice of High Court, it is not mentioned in the Constitution, but a convention has been developed out of respect and out of the, the sanctity of superiority. So in that way, the senior most judge he is appointed as Chief Justice of India. However, this convention it was broken twice. In 1973, A.N. Ray he was appointed as CJI, superseding three senior judges. And again, M.H. Beg he was appointed CJI, superseding Justice H.R. Khanna, both during the reigns of Indira Gandhi. Then, what Constitution has said about the appointment of the judges of Supreme Court and High Courts, it is that judges will be appointed by the President after consulting the CJI. So again, a new caveat, what this consultation means. So this in effect meant that the final decisions in the matters of appointment it rested with the Council of Ministers, because If you may be able to recall that president is bound by the advice tendered by Council of Minister. So, in short, president is has to act according to the decisions made by Council of Minister. In that way, if judges of Supreme Court and High Courts they are appointed by president, it means they are appointed by the Council of Minister, which becomes an executive and political process. So this matter it went for interpretation of constitution because the question was what is the status of consultation with the chief justice, क्योंकि अगर काउंसिल ऑफ मिनिस्टर को ही अगर अपॉइंट करना है, if प्राइम मिनिस्टर एंड हिज चोजन मिनिस्टर वही अपॉइंट करेंगे जजेस को, देन कॉन्स्टिट्यूशन में जो कॉन्स्टिट्यूएंट असेंबली मेंबर्स हैं उन्होंने ये कंसल्टेशन विद द सीजीआई ये क्यों लिखा? बिकॉज it then becomes a rubber stamp kind of situation. So this matter it came before the Supreme Court between 1982 and 1998. So there were multiple interpretations. So initial interpretation was that court felt that the role of Chief Justice it was purely consultative. It means CJI उसको अपना opinion president को बता देना है. In short, Council of Minister को via president बता देना है. And now the ball rests with the court of the decision rests with the Council of Minister वो consultation माने या ना माने. Then जब second time the matter came before the court, they came with the opinion, with the interpretation that the opinion of Chief Justice it must be followed by the President. So it means that the consultation or the opinion of CGI it is binding upon the President. So now President he has become sandwiched between two giants. First, the opinion of Chief Justice of India, which according to the Supreme Court is binding upon the President. Then the advice of Council of Ministers is also binding upon the President. So here in this sandwich situation, the Constitution has not talked about any discretion that is available for the President to choose between the advice tendered by the two branches or to find a leeway. So the Constitution has not mentioned if there such kind of situation will ever arise. पर ऐसा पॉसिबल नहीं था. जो कॉन्स्टिट्यूएंट असेंबली मेंबर्स ऐसा कॉन्स्टिट्यूशन डायनामिक कॉन्स्टिट्यूशन द वर्ल्ड्स बेस्ट कॉन्स्टिट्यूशन बनाया है, बट ये सिचुएशन could not have been slipped out of their mind. So maybe they did not think this way. Maybe this was not the correct interpretation because president, the representative of the whole country, the executive insignia of the whole country, he cannot be bound by Chief Justice and Council of Minister all the time. And ऐसी situation है उसके लिए कोई रास्ता भी has not been found in the constitution. So this interpretation was also trashed. Finally, the Supreme Court it has come up with a novel procedure, a middle way kind of, and it suggested that Chief Justice it should recommend names of the person to be appointed in consultation with four senior most judges of the court. So the newer interpretation it was a collegium. Collegium means now Chief Justice of India he will in consultation with four other senior most judges will decide the names of the person, a list of names of the person who will be appointed to both high courts and supreme courts. And this list it would be provided to, it would be recommended to the president. And now the situation is clear. The president, he has a list of names which has been broadly consulted, CJI plus 4 judges, and now he can forward the list to the Council of Minister, and then the Council of Minister will point out the name who will be appointed to the judiciary. Judiciary here means both Supreme Court and the High Courts. So the latest interpretation is about a collegial system or the principle of collegiality. Then let's have the the talk of the removal of judges. So the removal of judges of Supreme Court and High Court is also extremely difficult. So a judge of both Supreme Court and the High Court, they can be removed only on the ground of proven misbehavior or incapacity. So any other reason will not be counted as for the removal of judges. Then the procedure itself, a motion that containing the charges against the judge, it must be approved by special majority in both the House of Parliament. So special majority is 2/3 of present and voting. So this is the toughest majority that could be gathered by the members of parliament, और यही majority ये constitutional amendment के अंदर भी the procedure remains the same. So all in all, the appointment process, in the appointment process, executive plays a crucial role, or removal may judges has the power of removal. And by this, the Constitution Assembly members, they ensure the balance of power and independence of judiciary. And there has been one unsuccessful attempt to remove a judge. So in 1991, first ever motion to remove a Supreme Court justice, it was signed by 108 members of parliament. So Justice Ramaswamy, so during his tenure as Chief Justice of Punjab High Court, he was accused of misappropriating funds. So his removal process, impeachment process, they started in the parliament, and the high-profile inquiry also found Justice Ramaswamy guilty of willful and gross misuse of office. But then the motion of impeachment, it could not garner the required 2/3 majority among present and voting, because Congress party it abstained from voting in the House, and that's how Justice Ramaswamy survived the impeachment motion. So this is it. Thank you very much, and kindly subscribe the channel.